evening.
My name is Andrew Crawford, and I'm here on behalf of Deborah Cornelius, the appellant in this case. I respectfully ask to reserve 5 minutes for rebuttal.
Okay.
Your Honor, this case arises from Pinellas County after a conviction for aggravated assault and resisting arrest without violence, one a felony, one a misdemeanor. There's two issues involved in this appeal, and at the outset I'll acknowledge that there weren't specific objections made regarding some of these comments, so it'll be viewed from a fundamental error analysis.
But all the cases you cited, none of them use a fundamental error analysis. Is that correct?
That is correct, Your Honor. I did not find a case that specifically said that as it related to the Fourth Amendment. There was only 3 cases that I found in Florida jurisprudence as it related to that. The cases I cited, again, all hold that it is a constitutional error of the same magnitude, a comment on a defendant's Fourth Amendment rights, just like it is on a defendant's Fifth Amendment right to remain silent. Specifically in this case, there were numerous instances where there were comments on Ms. Cornelius's right to refuse the consent to enter her residence and search for the knife that was allegedly used in this case.
Well, who brought it up in the first closing argument? Defense counsel, right?
No, the state attorney.
They brought it up in rebuttal.
No, they brought it up in the first closing argument. Actually, they brought it up first in their opening statement.
Well, that's what I wanted to ask you. It was first mentioned. I know the state has taken the position that this was in response to the theory of the case, but if in looking at the record, the very first incident happened, what, at opening statement?
Correct. The state attorney.
And exactly the quote that was mentioned at opening was what?
The quote that was mentioned in opening specifically was, which I believe is found on page 177 on the record, or 175 on the record, which is in volume 2, was, I believe, that something to the effect of, and of course the officer asked for consent to search, and she said no. Something to that effect. So it was, in fact, the prosecutor, not the defense attorney, who brought that up. The defense attorney responded to that after the prosecutor raised it in opening. That statement was reiterated by the officer during his direct examination, and again by the prosecutor during his initial closing argument and his rebuttal closing argument.
So in the opening statement was not objected to.
Correct.
In the direct examination, not objected to.
Correct.
And the closing, both in the initial and in the rebuttal, still not objected to.
That's correct.
So the question for us is this fundamental error,
yes,
such, and we have to make that analysis. And if it's fundamental error, where do we even look at the harmless error analysis? Does that apply?
I think the first determination for this court is whether or not it is in fact fundamental error. I would argue that it is fundamental error based on the fact that it's not a single isolated comment. It's made numerous times during the course of the trial, and it goes to a disputed element of the offense, which is the fourth element of the aggravated assault jury instruction, which whether or not there was in fact a knife.
Well, wait a second.
Yes, sir.
Whether in fact there's a knife, you don't need a knife to prove aggravated assault.
You do. Well,
you need testimony that a knife was used in a threatening manner, and you have 2 people, the victim and his eyes, saying the knife was used in a threatening manner. The officer had the absolute right to go in there and arrest this woman under the statutory authority to arrest for a felony not committed in his presence, and that he had probable cause for a felony.
He might have had probable cause in the felony, but that does not change the United States Supreme Court ruling that you can't enter someone's house in order to effectuate a warrantless felony arrest.
Now that's a bold statement. She's grabbing onto the doorway as he's pulling her out to effectuate the arrest. Where is the entry in that? And if there is somewhat of an entry to pull her hands off the door jamb, why wouldn't that be a jury question as to whether he entered or didn't enter?
Well, he did in fact enter the residence according to the victim's testimony found on page 211 of the record.
Are you taking a portion of the case and saying that's the whole case, or are you discounting the state testimony?
I'm discounting the state's. Well, if you look at
we're not permitted to do that. We can't reweigh the evidence.
I understand. There is disputed testimony. The officer said she was halfway in and halfway out of the residence. The alleged victim in the case specifically testified they went inside of her residence for 30 or 45 seconds on page 211 of the record.
Okay.
Still, I would argue that it's impermissible to enter a residence or yank someone out of a residence to effectuate a felony arrest without a warrant, an arrest warrant.
Well, I think that's different from the statute, and I will be happy to get the citation momentarily, and we can talk about that. I think it's 901.115 subsection 3. In any event, I don't want to change your flow. You can keep going with your argument.
And if I may, but I mean, that all may be well and good, but as I understood your argument on appeal is that you're not questioning the fact whether or not the officers had a right to arrest her.
No.
I think as I hear your argument, this is what I want you to focus on,
Yes.
is you're taking the position as the statements that were made by the prosecutor during opening, and then the statement that will elicited during the direct exam, and the statements in closing regarding the fact of them not being allowed to go in her house, that is fundamental error.
Correct.
Okay, and with that then, the state is taking the position that it's really a misstatement, that the officer asked, "Can I come in?" And you're taking the position that the officers basically said, "Could we come in and search?" So why don't you take a moment to elaborate on that?
Certainly. There's two statements essentially that were made. The first one, well, there's four that are made, but the first one where it was initiated by the state was that she refused permission to search her house. That was the opening statement. The officer was then asked by the prosecutor on direct examination whether or not he entered the residence. And in entering the residence, his response was no. She said not without a search warrant.
Okay, let's focus first
Sure.
on the opening statement, because let's just see, okay, I have it right here. The opening statement, here's what the prosecutor said. So Officer Marinville attempts to gain consent to go in and to look in the residence to see if he can get the knife. And of course, she says, you're going to need a search warrant and that you can't go in there and search for the knife. So that's the statement in opening.
Right.
The statement by the prosecutor saying that the officer was trying to gain consent to go in and to look for the knife. That aspect of it, and that obviously was not objected to. So that's one thing, okay? And then the next one, when you're making references to the direct, I want to be able to look at the exact questions.
Certainly.
Because let me just say this, I'm troubled with the fact that throughout the case there was a theme, the theme of she did not allow us to go in, she did not give us consent, and I'm concerned about that, but I'm trying to weigh whether that rises to the fundamental error aspect. That's my concern.
Certainly. As it relates to fundamental error, I think one of the things that if you look in other cases as they cite to the Fifth Amendment, because there's not nearly as many as it relates to the Fourth Amendment, I can only find 3, that one of the things that the appellate courts look to is the number of times and whether it pervades and goes to a disputed element of the offense. Specifically in this case, the disputed element was whether or not there was a knife. Well, I understand, as Judge Volante mentioned, that there were 2 witnesses that testified that there was a knife, although giving different descriptions of the knife. The state used those comments to suggest to the jury that, obviously they don't come out right and say it, but clearly the implication is that she's guilty, there's a knife in the house, and she was hiding. And that is what I would assert rises to the level of fundamental error.
Okay, because she was charged with what, aggravated battery?
Aggravated assault.
I'm sorry, aggravated assault. Wasn't also testimony presented that she got so aggravated when they came in to repossess her vehicle that she actually grabbed pieces of paver to throw it at the car and then made a comment about this car was not worth anything anyway?
I don't think that was her exact words, but yes.
Well, I kind of paraphrased. I didn't want to use exact quote here.
I didn't either.
Okay.
But yes, there was testimony by both the victim and the other repo man who was with him to that effect.
So would that by itself be sufficient for the jury to come back and finding of aggravated assault without this whole issue with the knife?
No.
Why not?
Because the information specifically alleged to wit a knife, not specifically a paver stone, so she was not charged with the paver stone. Additionally, in that scenario, I could be wrong, but I remember that the testimony was they were sufficiently away from the vehicle where she was directing the paver stone at the vehicle, not these 2 individuals.
Okay. And I interrupted you. You're about to tell me about the direct examination.
Certainly.
Let's go there.
The direct examination, the state attorney is asking the officer whether or not he entered the residence. and asking at the same time whether or not he read Ms. Cornelius her Miranda rights. And the response from the officer was, no, I didn't go inside the residence. She said, not without a warrant, so no. That was the officer.
The officer volunteered half of that answer. The answer was, did you go in the residence? It could have been a yes or no.
Correct. The officer did volunteer.
So it was kind of unsolicited, and there was no pretrial motion in limine to prevent the officer from blurting out something of that nature.
There was no pretrial motion in limine. However, I think that in terms of whether or not it was intentionally elicited, I would direct Your Honor back to the opening statement, where that was the point, in his opening statement, that she refused to consent to entry to that residence.
Well, let's go back to that direct, because that's another thing that I want to focus on. Okay, and I have the colloquy right here. The state asked, did you ask to be allowed to enter into her house? And as Judge Valenti said, the officer blurted out, she said, not without a warrant. Instead of the prosecutor stopping, he then asked, okay, and the officer said, so no. And then the state said, did you have a warrant? And the officer said, no, sir. All right. Did you later obtain a warrant in this case? The officer said, no, sir. The state, all right. Why did you not obtain a warrant in the case? And then the officer said, I have no answer for that, sir. And then the state says, okay, did you ever go inside of her apartment? No, sir. Did you ever conduct a search of her apartment? No, sir. And maybe this question is more directed for the state attorney, when the attorney general, when they come in. Is it really isolated? Is it really,
no.
Does that pervade?
No, the issue that pervades this entire trial, which occurred during, I believe, a one-day period of time, is specifically that a knife was involved. There's an allegation a knife was involved. The officer asked for permission to search. Ms. Cornelius asserted her Fourth Amendment rights and said no. That was mentioned again during the state's opening, the direct examination, and during both of their closing arguments. Therefore, it would not be a single isolated comment. It would be a repeated comment that occurred and was revealed to the 6 members of the jury on multiple occasions.
Okay, how about then the argument that on cross-examination, the defense attorney did ask some questions regarding that? Would that be almost like a waiver of that type of error? Because if you see the questions and answers, the defense attorney basically said, all right, something to the effect that the defense asked, and then you ask her if you can come into the house, right? And the officer said, yes, ma'am. And she said, no, you're telling me anything I could say and will be used against me. You can't come into my house. The officer said, yes, ma'am. And the defense, and she was right, you would have needed a warrant to go in, yes, ma'am. And you could have gotten a warrant, yes, ma'am, but you didn't, no, ma'am. Why would that have vitiated any type of error?
That wouldn't have vitiated any type of error because, again, the defense attorney in that situation should have objected, but had, in that situation, when they didn't object, had to respond to the state's assertion.
But they could have moved for a curative instruction. They could have moved for an objection. Instead, it looks like they responded as though it was part of the trial strategy to show ineptness on the part of the officer. I mean, the minute they take the bait and say, well, you didn't go into the house, you didn't get a warrant, there's no knife, and that's the theme through closing, the defense doesn't testify. So really what the argument boils down to, the defense was a failure of proof on the part of the state. That's the whole defense is the state didn't prove the case. And you've got this angry person saying, we're going to be on TV, jumping around, yielding a knife, throwing pavers through the windows, just like you see on TV, the repo case, but it didn't make it to TV. And that was, to me, the jury could presume without even being asked that of course she's going to say, no, you can't enter my house. A person that angry that throws bricks in their own car, they're not going to give consent, but it came out. And no curative and no objection. It has to be a harmless error analysis. And fundamental error, sure, you can sit back and defend the case. But I don't see how you survive a harmless error analysis on this.
Well, Your Honor.
I just want to let you know you're at 15 minutes.
Thank you. I'll reserve the balance of my time.
Okay, thank you.
Good morning. May it please the court, my name is Jason Miller. I have the distinct honor of representing the state of Florida in this case, the appellee.
Okay, Mr. Miller, the question that I've asked counsel, I'll tell you what I'm concerned with, quite frankly.
Yes, Your Honor.
The state, an opening statement, so it's not in response to their theory of the case, and I know your position on appeal, this was in rebuttal to, you know, the defense's theory. But in opening statement, the state comes out and says about that, and then elicits that same testimony during direct, and then in closing, and the state had the first and last, brings it up again. So
Yes,
there's
Your
that pervasive theme. She didn't let us go in. She didn't let us go in. Almost like the implication is, well, she has something to hide. She didn't let us go in. I'm concerned about that.
Well, almost like the statement you gave, it's almost like she's got something to hide, but that's never stated. And I would address something that Judge Valente just commented on, that if it's seen as pervasive, it's just as reasonable to be a theme of the defense. The defense being that, to answer your question directly, that the defense was that the officers didn't do their job, the officers didn't make correct observations, and so their testimony should or shouldn't be believed, which was in fact argued in closing argument. And so if that's the theme of the defense, then they're going to need to, the defense, in fact, on cross-examination is going to need to bring out those facts. And so the context in which that is brought forth in opening statement by the state, in direct and rebuttal examination during the body of the case, and then also in closing argument, the context is where I'd like the court to focus. Because in the Fourth Amendment analysis differs from the Fifth Amendment analysis in that it's not just the invocation of the right or the comment that needs to come out, but also it is the argument at the end that it's implying some kind of guilt by association. In other words, somebody would be hiding behind their Fourth Amendment right. In cases that are cited in the brief, they are hiding. Why else would someone refuse a search unless they're guilty? That kind of thing is actually argued in closing argument. That's absent in this case, and from the context of the way it is brought up, it seems clear that it's essentially a response to the claim that the police officers didn't do their job, when in fact they're following the law. If she says not to go in,
well, you know what,
they don't go in.
I think your position may have been stronger if the state did not say this in opening statement. If the fact that the state laid it out there, couldn't the defense say, we have to do, okay, they laid it out there, it's now in front of the jury, what can we do to kind of soften that and to use that approach? And you said something, and I think it's in your brief here. Are you taking the position that the state absolutely had to argue that this is a consciousness of guilt for it to be error, as opposed to letting it, you know, subtly being mentioned to the jury?
Case law indicates that there has to be that implication. There has to be an
implication.
implication.
Okay.
An implication that is argued. So it has to be argued that there's a consciousness of guilt. It's not just that the fact is out there and it's kind of floated for the jury to then absorb. It's actually argued in closing argument that this invocation of rights goes to an element, goes to an issue of knowledge, it goes to some element of the offense, and that's the implication of guilt that is inside the argument. It's presented in our case in a different context, and it's clearly stated in closing argument that the defense clearly argues that the knife is required. They make the argument to the jury that the statements aren't enough. The statements by the two witnesses are insufficient, and that the knife is required. So if that's their closing argument, of course, the state may, it's a perfect strategy to preempt what appears to be a defense by the defense. So the strategy could be, and seems to be, that they wanted to preempt that.
Well, I mean, let's just assume, though, for the sake of argument, that it wasn't proper for the state to bring up the lack of the search warrant in the opening, because that's not in response to anything. That's anticipatory of the defense.
Yes.
So let's put that in context.
Sure.
Because if it's fundamental error and the state brings it up, you got a problem. If it's a harmless error analysis, what unfolds after provides the context, and that's why they didn't object, and it becomes a harmless error analysis. It doesn't appear like there's harmful error without preservation. And all the cases the defense provides, all the argument is preserved, except one we don't know. It doesn't go into that, Fletcher or one of those cases. But generally, it's a harmless error analysis.
There are
this isolated comment. The rest, the context is pretty clear. It's part of a strategy on both sides to use the absence of the weapon to their advantage or to mitigate. It doesn't really matter. And here's why the weapon wasn't recovered. Plus, you go in someone's house, you're going to find 15 different knives.
Yes, Your Honor.
With their prints on it. I don't know that would have added a whole lot even if they recovered the knife, but that argument wasn't necessarily made.
I think to answer the question in parts, I agree with what you're saying, and to address the harmless error analysis, it's the appellant's full burden to show fundamental error in this case. Fundamental error, as we all know, has to be so great, is pervasive as to eviscerate the entire trial, such that the facts could not support the conclusion, the jury's verdict, the time served sentence in this case. And if it's of that magnitude, and it is fundamental error, there's courts that say harmless error is not necessarily relevant to that first analysis, and it's their burden. To shift the burden back to the state would be step two, but you'd have to find fundamental error first, which would be of such magnitude to essentially overshadow it. And I don't think we actually get to the harmless error analysis because of this magnitude of fundamental error that's required. But as an exercise, certainly, there are cases that at least mention it and in doing the exercise. And the particularized statement that is an opening statement by the prosecution doesn't have that second step that's required under the Fourth Amendment analysis. It doesn't say anything in there that there's an implication of guilt, an implication that she's hiding evidence, an implication.
So, I mean, you're saying that there has to be, the prosecutor or the state has to say that her exercise, then it's almost like this was a bad question, let me rephrase it. Are you taking the position that there has to be absolute statement regarding consciousness of guilt elicited by the prosecutor for it to be the fundamental error?
The reason why I would make a statement like that is because I would look to the case law in which cases are reversed. And they are reversed under a different standard where there was objections in the lower court and it was preserved and it does move on. And in those cases, yes, there's an actual statement that says this goes to her consciousness of guilt. Why else would someone refuse a search for a gun unless they have a gun? Why else would someone refuse search of their car for drugs unless they knew drugs were there? And in those cases, and even in those cases, they do somewhat of a harmless error analysis where they will then go and look at the elements of the case. And in the search case, the only piece of evidence that showed knowledge of the drugs was this implication. And so if we remove that, it was completely circumstantial. There's no evidence to support the verdict, and so it couldn't be supported on the evidence other than the alleged error, and so that case was reversed. In our case, we just have the one statement that we're discussing in opening anyway.
One statement in opening, then direct, then closing the first, then closing and rebuttal.
And all along the context.
And the whole theme, and that's what's troubling. So I know you're taking position this is an isolated comment. I don't see it that way. I just see that there was this pervasive theme. The prosecutor didn't come out and say this shows consciousness of guilt,
right. But
the implication is that she did something wrong. She should have allowed us to go into her house. That's what's the troubling thing for me. And
well,
so
I see from closing argument what the implication all along seems to be. And if when I say it's isolated, I think the context is isolated. It's isolated to this one particularized context. It's not pervasive in the sense that they're using it. Certainly not in closing argument. There are no words specifically that say pointing a finger at her for hiding behind the Fourth Amendment.
You're absolutely correct
right.
on that. You're absolutely correct.
So I think what Your Honor is saying that the amount of words to the effect can lead to that implication, but I would argue that the words are basically isolated to the context of the police officers, the reason why the police officers didn't go in and search. Why, the question was posed by defense and was posed on closing argument. Why don't you have the knife? And
Well,
the prosecutor said...
they could have easily, Mr. Moe, they could have said, well, you know, the state did not need to get into that area, that issue about, well, she didn't let us go in. She didn't let it go in.
They didn't need to, because there was sufficient evidence otherwise. And to get back to Judge Valente's question about harmless error, part of the harmless error analysis is, the fundamental error analysis is whether the verdict could be justified on other evidence. And clearly, there's two witnesses testifying regarding the presence of the knife and the existence of the knife exactly the same. They say exactly the same thing, that she had the knife and she used it in a threatening manner. There's a dispute over the color of the handle and the size of 6 inches or 12 inches, but regarding its existence, there's ample evidence for which the jury could convict based solely on that testimony. And that was essentially the closing argument, is the defense was saying that there's insufficient evidence to convict if it's just testimony. And the state said that is sufficient. And on count 2, there was a discussion about the police officer's credibility or testimony regarding whether it was actually resisting arrest or not. And in cutting against the officer's credibility, they tried to indicate that he didn't do his job. The defense was that he didn't follow. He could have searched. He could have got a warrant. He could have done a number of different things, and he didn't do that. And in response to that is where this context of why didn't he get a warrant, why didn't he search, why don't we have the knife? So in that explanation, when I say it's isolated, that's what I mean it's isolated to. It's isolated to that context.
Didn't the defense counsel explain the concept of and the process of obtaining a search warrant in closing to the jury? They had probable cause for an arrest. It means they had probable cause to get a search. They expounded upon this, a lack of a warrant situation, and they could have gotten the warrant, and where's the knife? And that goes to element number 4, the crime.
Exactly, Your Honor, exactly. And that goes to that theme of defense and why the state would have to bring up the fact that the officer did do his job. One of those instances of facts of how the officer did do his job is by following the refusal of the homeowner. Homeowner says, don't go in my house, and he didn't go in his house. So so the state gets to make the argument the officer in fact did do his job and did follow the Constitution. And so, unless there's any questions from the court, I'll take my leave. Thank you very much.
Again, this was fundamental error. It was raised...
Well, can I ask you a question? Because in arguendo, if it's not fundamental error, do you concede this is not a reversal?
The law of Florida says that in order for this to be preserved, absent fundamental error, that there must be a contemporaneous objection or a motion.
I'm going to take that as a yes, then?
Yes. That's what the law says. But again, in this case, there's 4 specific instances of that. I respectfully disagree with the state's position that you can take each one of those comments and somehow isolate them based on the context. For example, if this was a Fifth Amendment issue, I understand it's a Fourth Amendment, you couldn't just say, well, based on the context, it actually was fairly susceptible of a comment on a defendant's right to remain silent. Just like that here, there's a fundamental difference from saying the officer didn't get a warrant, which would be a normal part of cross-examination.
Yeah, but once the testimony comes out, whether it came out correctly or incorrectly or rightfully or wrongfully, testimony is part of the evidence, and both sides are entitled to comment on it, and both sides did.
The question is, who brought that up first, which was the state attorney, not the defense. The defense in that position had to strategically...
If it wasn't part of the trial strategy, there would have been either a motion in limine or a request for a curative.
Or an objection.
Or something other than a response as if it was anticipated. I mean, it's hard to go back in a time clock and say these attorneys did such a great job that they argued effectively both sides of the coin. but sure looks like they argued effectively both sides of the coin, as if they anticipated the argument, prepared for it, made the argument. They didn't lose a second in addressing it. It wasn't as if it was a surprise.
Still, it's impossible to say from the record before us what trial strategy actually was.
Well, that's what I was going to ask you. Can we really tell based on this? The opening statement goes on. I mean, at one point, can you argue that this is ineffective assistance of counsel? I know you didn't argue that, but...
I didn't argue that.
Because, I mean, this is a direct appeal.
This is a direct appeal, and unless it's apparent from the face of the records, the court knows it's not something that I'm allowed to do. I think the issue is more couched.
Well, exactly. It is not apparent from the face of the record, because I honestly, I don't know how you look at this and not read it as defense strategy, as opposed to ineffective assistance. Again, so how could I look at this and not and be persuaded that this wasn't defense strategy? Gave them a great defense.
It's impossible from the record before us.
So how can we conclude it's fundamental error then?
Because the fact that it's impermissible to comment on a defendant's Fourth Amendment right, which was done here on 4 separate occasions.
Well, it sounds like you're arguing like per se error.
I know, I'm definitely not arguing per se error.
Okay, well then for it to be fundamental, it has to be harmful.
Correct.
Okay, if this was defense strategy and it actually gave them a defense, how is that harmful?
But it did not give them a defense by saying...
Well, they argued it as a defense.
I understand. They argued it. Well, they argued that the officer didn't obtain a warrant when he could have.
Right, exactly. They used this the defense used it to its advantage.
As any defense attorney would, that an officer could have obtained a warrant but didn't.
So how do we then get over the harmless error obstacle in this?
The harmless error obstacle, because it was mentioned multiple times by the state. The fact that it pervaded, and the theme throughout the trial was she did not consent to a search of a residence, i.e. a knife was inside. And the fact that it is constitutional error of the same magnitude of the Fifth Amendment to comment on a defendant's Fourth Amendment rights to refuse consent to search. There's a fundamental difference between cross-examining an officer and saying, well, you could have obtained a warrant and you didn't, than the state bringing up an opening statement. She was asked whether or not she could search the residence, and the officer said no. The clear implication there, it doesn't have to be, the state attorney doesn't have to argue consciousness of guilt. The state attorney, there only has to be an implication that's raised for it to be error, according to the case law. And since it was done 4 times...
I don't even see how an implication's raised, frankly. I'm not sure that I agree with you on that.
When the prosecutor mentioned it in his opening argument in the context of the knife?
That was conscious. I mean, how... consciousness of guilt. If it was in a different factual scenario, I could see it. But in this, you go into a home, chances are you're going to find a knife.
True, but in the context of the opening statement, the prosecutor specifically said they were looking for a knife, and of course she refused to consent. Clearly, the implication there is that there was potentially a knife in there, and it's consciousness of guilt by not allowing them to search.
Well, okay. Well, that's your argument.
I understand.
Yeah.
And I'll respectfully disagree with the court.
Okay.
But that's what I'm arguing.
I mean, if you had a he said, she said, your case would be stronger. You don't quite have that. You got all kinds of evidence, and you have that independent witness. I mean, apparently there was no denial that she's running around like a mad woman with this knife, trying to get on TV and threatening these guys, the repo men. And then they don't have the knife, and she doesn't want to give consent to avoid a warrant. And they could have gone back with a warrant, but they didn't. They didn't get the pavers either. They could have gotten a warrant for that. I mean, that's kind of like a non-starter honestly, from my perspective.
I understand, Your Honor. But again, I think there's a major difference between saying, we asked her for consent, she refused, and saying the officers didn't get a warrant. Those are 2 separate issues, one of which is impermissible according to Florida case law, and one is not.
Right. The timing could have been better. I'm not... I mean, the state could have done it a little bit differently. They could have used that in rebuttal, but they didn't.
Correct. And at that point, the defense had to do what they had to do and try to mitigate the damage.
Okay.
Thank you.
Thank you, Your Honor.
Thank you both.
Thank you.
All right. Our next case this morning is Morgan versus Walker.